to the fallout after the Supreme Court struck down President Trump's tariffs. The president lashed out at the justices and doubled down, signing an executive order to bypass Congress and impose new tariffs. Senior political correspondent Rachel Scott is at the White House. Good morning, Rachel.
Michael, good morning. And just moments ago, the president lashed out at the high court again, calling them incompetent. But he is defiant, insisting he has found another way to impose a 15% global tariff just days after the Supreme Court ruled that most of his tariffs were unconstitutional. Under this law, though, the president can only impose those tariffs for about 150 days without congressional approval, something he says he will not do. The Yale Budget Lab estimates that this could cost the average American family about $1,300 a year. The 6-3 decision knocked down the heart of the president's economic agenda. 3 conservative justices, including 2 President Trump appointed, Neil Gorsuch and Amy Coney Barrett, joining the liberal justices to declare the president's tariffs unconstitutional. The president says that he is ashamed of those justices, calling them an embarrassment to their families. And of course, those justices will be seated just a few feet away from the president tomorrow at the State of the Union address, guys.
Okay, Rachel, thanks very much.
All right, friends, Dr. John here. So what just happened, guys? 2 sides of the same cage are closing at once. The Supreme Court slapping down executive overreach from one direction, Congress sharpening its removal tools from the other. These aren't separate storms. It's one constitutional thunderstorm hitting from 2 directions simultaneously, and it's the direct consequence of a presidency that spent years stretching its legal authority past every limit, betting the institutions would stay asleep.
Today, Pope Leo, in a rare statement in English, so Donald Trump could understand him, he directed a statement at Donald Trump that tried to convince Donald Trump to not go through with his threatened war crimes today against Iran.
Asking all people of goodwill to search always for peace and not violence, to reject war, especially a war which many people have said is an unjust war, which is continuing to escalate and which is not resolving anything. Let's remember especially the innocent, children, the elderly, the sick, so many people who have already become or will become victims of this continued warfare. To remind all that attacks on civilian infrastructure is against international law, but that it is also a sign of the hatred, the division, the destruction that the human being is capable of, and we all want to work for peace.
They didn't. The Supreme Court case, Learning Resources versus Trump, ended with a 6-3 decision that flatly rejected the president's claim that the International Emergency Economic Powers Act gave him the power to impose the kind of globe-crushing tariffs he had been using as the battering ram of his second-term economic agenda. Chief Justice John Roberts wrote the majority opinion. And here is the kicker.
Also today, our next guest, Democratic Senator Ed Markey of Massachusetts, who has voted twice to stop Donald Trump's illegal war in Iran, said, quote, "We have a warmonger in the White House. He has threatened war crimes on an apocalyptic scale and appears eager to commit them. The House and Senate must return to session. The House must pass articles of impeachment, and then the Senate must vote to convict and remove the president, or the cabinet and vice president, with congressional concurrence, must invoke the 25th Amendment and remove Trump. His threats cannot be dismissed as mere rhetoric. This is as grave a moment as the world has faced in the nuclear era." Joining us now is Democratic Senator Ed Markey of Massachusetts. Senator, thank you very much for joining us tonight. What is your reaction to Donald Trump, as Iran puts it, surrendering now and stopping his war, leaving Iran in control of the Strait of Hormuz?
2 of Trump's own hand-picked justices signed onto it. Reuters called it a rare public censure, a judicial spanking in plain view, showing that even this president has a constitutional ceiling he cannot smash through. The ruling dismantled his long-standing argument that he could unilaterally rebuild American trade policy just by declaring a national emergency.
Yeah, Donald Trump has surrendered, not the Iranians. And what he has been doing over the last several days is an impeachable offense. He has threatened a genocide against the nation. He has threatened to end a civilization. He has threatened to use nuclear weapons against a country that does not have nuclear weapons. All of these are impeachable offenses, and he must be brought to justice. The House and Senate should be brought back into session. There should be articles of impeachment brought against him by the Democrats in the House of Representatives. We need to make Donald Trump accountable for what he has just done in the name of the American people. And I think this is going to be a defining moment for the Congress, for the American people. We cannot allow Donald Trump, in control of nuclear weapons, to be invoking this madman theory of the destruction of a civilization in the name of the American people without him being brought to accountability. The impeachment process must begin.
NBC and the BBC both reported that this decision wiped out a central pillar of his second-term strategy and left him with a brutal choice: go crawling to Congress for new tariff authority or abandon the whole idea entirely. Now, at the exact same time, coming from the legislative side of the double squeeze, constitutional experts writing in the Independent Institute.
We have reports tonight of over 50 House Democrats agreeing with you on this, over 20 Senate Democrats agreeing with you on exactly this. I want to read you the one statement we have about this from a Senate Republican, and that's Senator Lisa Murkowski. Every other Senate Republican has avoided saying a word about it. She said, "The president's threat that a whole civilization will die tonight cannot be excused away as an attempt to gain leverage in negotiations with Iran. This type of rhetoric is an affront to the ideals of our nation, has sought to uphold and promote around the world for nearly 250 years. It undermines our longstanding role as a global beacon of freedom and directly endangers Americans both abroad and at home." But the rest of your Republican Senate colleagues are absolutely silent, along with the Republican Speaker of the House, who did not say one word about this today.
In Slate and the nearly 100 Democratic co-signers behind Congressman Larson's 13-count impeachment resolution are making a devastating argument. They say Trump's unauthorized war against Iran is textbook impeachment material under the framers' original design for war powers.
My Republican colleagues are spineless. They are in a witness protection program. It's almost like the invasion of the body snatchers. You look at them, they look like the same human beings, but inside it just MAGA controlled, Trump controlled. They just don't have the courage to stand up when something which is clearly a violation of everything that our country is supposed to stand for is being compromised by Donald Trump. And the question is, for them,
two simultaneous institutional checks, two different branches of government, both arriving at the same constitutional conclusion. This president has exceeded his legal authority in ways serious enough that the system demands a formal response. That is the double squeeze.
It's 40 days later. Are we better off today than we were 40 days ago? No. The Iranian army now controls the Straits of Hormuz and the price of oil for the world, and they can charge a fee for every ship which is going through. Do we control the uranium? No, we do not. The Iranian army still controls the enriched uranium that could hold the world hostage. Are the Iranian people free? No, they're terrified of our country, that we would blow up their bridges, their schools, their civilization. And has there been regime change? No, there has not. All we have is Ayatollah Senior replaced by Ayatollah Junior. So all of this has occurred in the last 40 days without a peep from the Republican leadership in our country. And there is something fundamentally wrong with our democracy when Donald Trump can threaten the use of nuclear weapons to destroy a civilization, and the Republican Party refuses to respond at all. And the American people are going to pay an Iran war tax every day they go to the pump. It's Trump at the pump. It's up $1 a gallon. It's not going away. We just have a 2-week reprieve, and it's going to ripple right through our economy. And ultimately, the voters are going to be coming with pitchforks for Republican House and Senate members this election in November.
Massachusetts Senator Ed Markey, thank you very much for joining our coverage tonight.
And it is producing the most credible, most legally grounded impeachment near moment of Trump's entire political career. Are you kidding me right now? The Supreme Court he spent years packing just ruled against him 6-3. The Congress he has been governing around for 2 years is now grabbing the constitutional tools the framers left specifically for this exact kind of crisis. And the combination of those two institutional responses hitting at the same time is what makes this moment fundamentally different from every previous time someone whispered the word impeachment. This time, the constitutional machinery is already moving from multiple directions at once. And the thing being cut is not the calendar. It is the practical power. Now let me give you the full, honest picture of what this double squeeze actually means, because that framing about cutting the term captures something real and specific that deserves a hard look. Trump's calendar term runs until January 2029. The Supreme Court cannot shorten that. Congress cannot shorten that unless they actually remove him. So what is being cut? What the ruling specifically and concretely cuts is the practical power, the toolkit, the specific mechanisms Trump was planning to use to dominate his second term through executive action instead of legislative process. The emergency tariff authority was never just a trade policy tool. It was a governance strategy. It was the demonstration that one man could reshape global economic relationships unilaterally through an emergency declaration, no congressional approval needed, on his own timeline for his own interests. The Supreme Court just said that strategy is unconstitutional. And legal experts connecting that ruling to the Iran war authorization questions are making a sharp and important argument. When a president both loses in the courts on emergency economic overreach and simultaneously conducts an unauthorized war in defiance of the War Powers Act, the constitutional remedies available to Congress are the same in both cases. Cut the power, assert congressional authority, and if the president refuses to accept either judicial limits or congressional constraints, remove him. That is the impeachment near argument, not a prediction that removal is certain, a constitutional analysis that the conditions for it are meeting each other in real time. Here is the specific legal holding of the tariff ruling and why its implications reach far beyond trade policy. The case challenged the sweeping global tariffs Trump imposed using the International Emergency Economic Powers Act as his supposed statutory authority. IEEPA is a 1977 law that gives presidents emergency powers to deal with unusual and extraordinary threats to national security or the economy coming from abroad. Trump used it aggressively and expansively to justify import taxes on virtually every major trading partner. The Supreme Court's 6-3 ruling said clearly and unequivocally that IEEPA does not give the president the power to levy these tariffs. The constitutional reason behind that holding is the Major Questions Doctrine. That is the conservative legal principle that when a president claims authority of vast economic and political significance under a vague statutory provision, courts require Congress to have clearly authorized that claim. The majority concluded that the clause Trump was relying on did not clearly authorize sweeping permanent tariff authority because no prior president in the statute's 50-year history had ever tried to use it this way. That holding is bigger than tariffs. The Major Questions Doctrine applies to every statutory claim of vast authority that lacks clear congressional authorization. And Trump's governance strategy across multiple domains has been built on exactly the kind of broad statutory authority claims that the Major Questions Doctrine was designed to reject. The tariff ruling is the most visible application of that principle, but it is also a signal to every court evaluating every other emergency power claim this administration has made about where the constitutional line is and how clearly they are willing to draw it. And then there is the War Powers impeachment connection, because this is where the constitutional scholars at the Independent Institute, at Slate, and the legal analysts tracking the January 6th immunity fight are now making their most specific argument. The constitutional design is simple. Congress declares war. The president commands the military. The president's war powers authority flows from the congressional authorization that establishes the legal foundation for the operation. The Iran war was launched without that congressional authorization. It has been sustained past the War Powers Act's 60-day limit without that authorization, and Trump has explicitly claimed the right to continue it until he alone chooses to stop, which is the most direct possible assertion that congressional war powers authority does not apply to his decision-making. The scholars arguing this is textbook impeachment material are not making a political argument dressed up in constitutional language. They are applying the specific framework the framers used when they designed the impeachment clause. The framers were explicit in the Constitutional Convention debates that the ability to wage war unilaterally was exactly the kind of monarchical power the Constitution was designed to prevent. They gave the war declaration power to Congress specifically as a check on executive war-making unilateralism, and a president who launches a major war without authorization sustains it past the statutory limit and claims the right to continue indefinitely based solely on his own judgment is the specific profile that the framers said warranted the most serious constitutional response available. Combine that with a Supreme Court that has simultaneously ruled he exceeded his authority on emergency economic power, and the two-front institutional rebuke is the constitutional context in which the scholars are saying the conditions for impeachment are not just present, they have been met. Let me go deeper into every dimension of what the double squeeze means and why the combination of the tariff ruling and the Iran war authorization questions is producing the most credible impeachment near moment of Trump's presidency. First, there is the practical power cut dimension, what specific tools and strategies the tariff ruling eliminates, and what it signals about the fate of every other emergency power claim. Second, there is the Iran war connection dimension, how the ruling directly affects the economic component of his Iran strategy, and why losing that component at this specific moment is strategically catastrophic. Third, there is the constitutional scholars' impeachment argument dimension, the specific legal reasoning behind the claim that unauthorized war-making is textbook impeachment material under the framers' design. Fourth, there is the Republican political calculation dimension, how the tariff ruling changes the math for Republican members already under pressure from the Senate walkout, the $200 billion supplemental, and the civilization-level threat controversy. And fifth, there is the historical significance dimension, what it means constitutionally that the Supreme Court, with his own appointees, has issued a ruling that scholars are describing as shrinking the practical power of his presidency in terms that will echo through American constitutional law long after his term ends. Let me walk you through each one carefully. Start with the practical power cut dimension, because the tariff ruling does not just kill one policy. It sends a constitutional signal that travels across every domain where Trump has been claiming authority through broad emergency statute interpretations. The governing strategy of his second term has been built on a specific constitutional theory that emergency statutes give the president authority to act unilaterally on matters of vast economic and political significance without going through the slow legislative process of Congress. The tariff ruling, applying the Major Questions Doctrine, says that theory is constitutionally wrong in the trade policy context. Emergency statutes of vast significance require clear congressional authorization. A 50-year history of the statute not being used this way is evidence that the authorization does not exist. That principle, articulated clearly by Chief Justice Roberts in a 6-3 opinion, with Trump's own appointees in the majority, is now the constitutional framework that every court evaluating every emergency authority claim this administration makes will apply. Immigration emergency orders resting on similar broad statutory interpretations, domestic security measures claimed under emergency authority, foreign policy economic coercion mechanisms that substitute executive emergency declarations for congressional authorization. All of those face a Supreme Court precedent that says if the claim is vast and the authorization is not clear, it fails. The tariff ruling cut the practical power, but the signal it sends about the fate of every other emergency power claim is the dimension that makes the cut most comprehensive and most lasting. Now examine the Iran war connection, because the timing of the tariff ruling creates a specific and immediate strategic crisis for the Iran operation that goes beyond the general weakening of emergency authority. Trump's Iran strategy has two components: military pressure through Operation Epic Fury and economic coercion through the threat of devastating devastating tariffs and sanctions. The Supreme Court just ruled the primary mechanism for the economic component unconstitutional, which means the foreign governments evaluating American leverage in the Iran situation, including Iran itself, can now do a specific calculation. The president's economic threat is legally constrained by his own Supreme Court. The tool he was planning to use alongside military escalation to pressure compliance has been ruled unconstitutional by the justices he appointed. His leverage is weaker today than it was yesterday. In a coercion strategy that lacks its economic component, at the same moment his military component is generating war crimes concerns, Senate walkouts, impeachment articles, and civilization-level threat controversy. This is a strategy that is losing its coherence faster than the administration can replace what the court keeps taking away. The ruling does not just weaken Trump domestically, it weakens his position in every international negotiation and every foreign policy confrontation where the threat of economic consequences was part of the leverage calculation. And that weakness, broadcast publicly by the highest court in the land, with his own appointees in the majority, is visible to every government that is watching. Now look at the constitutional scholars' impeachment argument, because the specific legal reasoning connecting the tariff ruling to the impeachment question is worth examining carefully rather than accepting as hyperbole. The scholars making this argument in the Independent Institute, in Slate, in law review articles and op-eds that are now being cited by the Democratic members pushing the impeachment articles are making a two-step argument. Step 1. The Supreme Court has now established in a written opinion with 6 justices that Trump's theory of emergency presidential authority is constitutionally wrong. He cannot use emergency statutes as blank checks for vast unilateral action. Congressional authorization is required. Constitutional limits apply. Step 2. The same constitutional principle that makes the tariff scheme illegal applies with equal force to the Iran war. Emergency declarations do not give the president authority to wage sustained military campaigns without congressional authorization. The War Powers Act exists precisely because Congress decided in 1973 that the constitutional principle needed statutory reinforcement, and a president who both loses in the courts on emergency economic overreach and simultaneously defies the War Powers Act on military operations is, in the framers' design, exactly the profile that warranted the most serious constitutional remedy available. The impeachment clause was designed for the case where normal legal and political checks have been applied and the president continues to act outside constitutional authority. The court said no on tariffs. Congress has been trying to say no through war powers resolutions. And the president has responded by claiming the right to continue his chosen course regardless. That sequence of documented overreach, documented court rejection, and documented continued defiance is the constitutional profile the scholars are pointing to. And the argument is grounded in specific constitutional text and specific historical framing, not in partisan political preference. Now let me analyze the Republican political calculation dimension, because the tariff ruling changes the math for Republican members in ways that interact with everything else they are already navigating. The fiscal hawks who walked out of the Iran war briefing, who are balking at $200 billion, whose political identity is built on fiscal responsibility and constitutional limits on government power, are now looking at a Supreme Court ruling that has validated the constitutional concern they have been privately expressing about the emergency power governing strategy. The ruling gives them a specific and judicial rather than partisan basis for saying the approach was legally wrong. It gives them political cover to distance themselves from the emergency power framework without having to directly attack Trump's agenda. And it creates pressure on the next vote, whatever that vote is, whether it is the War Powers resolution, the supplemental funding request, or the impeachment articles, because the Supreme Court has now publicly established that the constitutional line the administration has been pushing past exists and will be enforced. Republican members who have been hoping that courts would avoid the hard confrontations and give the administration room to continue are now looking at a 6-3 ruling with 2 Trump appointees that does the opposite. And their calculations about how to vote, what to say publicly, and how to position themselves for 2026 are shifting in response to a constitutional reality that the court has now made impossible to pretend does not exist. And here is the historical significance dimension, because what just happened at the Supreme Court is going to be part of how this presidency is remembered. And the constitutional record being created in real time is the legacy that will outlast the political news cycle. A Supreme Court with a conservative supermajority shaped in significant part by Trump's own appointments has issued a ruling that publicly declares the limits of his authority in a case bearing his name, with two of his appointees in the majority, using language that Reuters described as a rare public censure. That is the constitutional record. And the scholars connecting it to the impeachment question are doing something historically significant. They are arguing that the court has now provided the most authoritative possible validation of the constitutional principle that the impeachment advocates are applying. The president exceeded his authority. The court said so in his name, with his judges. And the question for Congress, the constitutional question that the impeachment near framing is raising, is whether they are going to do their part or leave the entire burden of constitutional accountability on the judiciary. Let me break this down into 4 clear points that give you the complete and connected picture of what the double squeeze means, what the tariff ruling establishes, why scholars are connecting it to impeachment, and what the political trajectory looks like from here. Point 1. The 6-3 tariff ruling with 2 Trump appointees in the majority is the most constitutionally significant judicial rebuke of this presidency because it establishes in a written opinion by the Chief Justice that the emergency power governing strategy Trump's second term was built around is constitutionally wrong. The Major Questions Doctrine, a conservative legal principle applied by conservative justices, says vague emergency statute authority is not sufficient for vast presidential power claims. That principle travels across every domain where the administration has been claiming broad emergency authority. The tariff ruling does not just kill one policy. It sends a constitutional signal that the courts will enforce the limits on emergency power regardless of the political cost. And that signal is already being applied in every pending legal challenge to every other emergency authority claim this administration has made. Point 2. The direct connection between the tariff ruling and the Iran war authorization question is the most specific and most legally grounded basis for the impeachment near argument, because both involve the same constitutional principle applied to different domains. Emergency statutes do not authorize vast unilateral presidential action without clear congressional authorization. The court said that about tariffs. Scholars are applying the same principle to military operations. A president who loses in the courts on emergency economic overreach and simultaneously defies the War Powers Act on military operations is in the framers' specific design for the impeachment clause. That is the profile the most serious constitutional remedy was created to address. And the constitutional record being built, the tariff ruling plus war powers violations plus unauthorized war plus civilization level threats, is the record the impeachment articles are grounded in. Point 3. The Republican political calculation changes when the Supreme Court, with Trump's own appointees, validates the constitutional concerns that Republican fiscal hawks and institutionalists have been privately expressing. The ruling gives Republican members a judicial rather than partisan basis for their discomfort. It creates political cover for the members who have been hoping for exactly this kind of authoritative external validation before they are willing to move from private concern to public action. It creates pressure on every subsequent vote, the War Powers resolution, the supplemental funding request, the impeachment articles, because the constitutional framework for evaluating Trump's conduct has now been publicly reinforced by the highest court in the country in terms that are impossible to dismiss as partisan overreach. Point 4. The historical significance of a Supreme Court majority publicly declaring the limits of a sitting president's authority in a case bearing his name with his own appointees in the majority is the constitutional event that the impeachment near framing is pointing to. The courts have done their part. They have said in writing that the emergency power theory is wrong, that the line has been crossed, and that constitutional limits will be enforced. The question the scholars and impeachment advocates are putting to Congress is whether Congress is going to do its part or leave the entire burden of constitutional accountability on a judiciary that has been doing everything the Constitution designed it to do while Congress has been hesitating. The term is being cut, not in the calendar, but in the practical power, ruling by ruling, vote by vote, from every institutional direction at once. And the impeachment near moment is the constitutional system saying the conditions have been met, the record has been built. The question now is whether the political will is there to match the constitutional moment. I will see you in the next one.